What are the downsides of using a joint will? Have you ever wondered what happens when two people decide to create a joint will? While it might sound like an easy solution for couples, there are some important downsides to consider. A joint will is a single legal document created by two individuals, often spouses, that outlines how their combined estate will be distributed after both have passed away. Let's break down the potential drawbacks of using a joint will, especially in the context of estate planning and the probate process. One major downside is the lack of flexibility after the first spouse dies. Once one partner passes away, the joint will typically becomes irrevocable. This means the surviving spouse cannot change the will to reflect new situations, like remarriage or the birth of additional children. Imagine wanting to adjust your estate plan to match your current life, but being unable to do so. This inflexibility can be quite limiting. Another issue is the restrictions placed on the surviving spouse's control over the estate. Since they cannot modify the joint will, their ability to manage or distribute assets is significantly reduced. This can be particularly challenging if they wish to provide for new family members or adjust inheritances based on changing relationships. The joint will may also limit what they can do with jointly owned property, which can complicate estate planning. Disputes among beneficiaries can also arise from the fixed nature of joint wills. Family dynamics can change after one spouse passes away, and the will may not address the interests of new heirs or reflected the evolving wishes of the surviving spouse. Such conflicts can lead to costly and lengthy litigation, which can deplete the estate's value and strain family relationships. Complications in the probate process are another downside. Joint wills often create challenges because they must account for the distribution of assets after both individuals have died. If the terms of the will become outdated or unclear, legal challenges may surface. This can lead to delays and increased administrative costs. Additionally, some states do not recognize joint wills, or courts may refuse to admit them to probate, which could necessitate separate wills or other estate planning tools. Finally, joint wills can be particularly problematic for blended families. Couples with children from previous relationships may find it difficult to adjust the will to accommodate stepchildren or new heirs. This can result in unfair distributions or unintended consequences that may not align with the couple's original intentions. While joint wills may seem like a straightforward solution for couples, their lack of flexibility, potential for disputes, and complications in administration often outweigh the benefits. For many, separate wills or trusts provide greater flexibility and better protection for both spouses and their beneficiaries. Consulting with an experienced estate planning attorney can help ensure that you choose the best approach for your unique situation.